Good evening and welcome. My name is Sarah Biddulph and I'm the Director of the Asian Law Centre, and tonight I'm delighted to be co-hosting this fabulous event with the Asian Australian Lawyers Association, and tonight Melina Astana, who's the National President of the Asian Australian Lawyers Association, graces us with her presence and will be helping to organise and to introduce the speakers. First, I would like to acknowledge country, to acknowledge the Wurundjeri people of the Kulin Nation, on whose unceded lands we are having this meeting this evening. I acknowledge their elders past, present and emerging. I welcome any Indigenous people who are here this evening. My task is very simple. It is to welcome you, to say thank you for coming this evening. This is a fabulous event. It's been many, many years in the making. And I think that you will agree that this project is timely. It's probably well overdue, and it will be a very important contribution to our understanding of the status and the difficulties facing culturally and linguistically diverse litigants in court proceedings. So now I'll hand over to my colleague Andrew Godwin, who will make some brief comments on background to the issues paper, and then introduce our guest speaker, who's appearing from New Zealand, unfortunately on Zoom and not here in person, Mai Chen. So Andrew, please.
Thanks very much, Sarah, and good evening, distinguished guests, friends and colleagues. First, thanks to all of you for joining us this evening, whether in person or online, and also for your interest in the issues covered by the issues paper that we'll be launching this evening. And while I'm on the subject of thanks, I'd like to acknowledge the logistical support by the team at the Asian Australian Lawyers Association and Melbourne Law School, and to thank them for that support. In particular, Ahalia Kamanini, Maria Gerlica and Lola Chang at the Asian Australian Lawyers Association, and Catherine and Astari at Melbourne Law School, the Asian Law Centre. So I think it was in the middle of 2019 that Sarah introduced me to Mai Chen. At that time, Mai was writing a report for the Super Diversity Institute of New Zealand on the challenges facing culturally and linguistically diverse parties in New Zealand courts. With colleagues at the Asian Law Centre, I had previously helped to design and deliver cultural awareness training to the Commercial Court of the Supreme Court of Victoria and also to the Federal Court of Australia. I was therefore delighted to have an opportunity to share my experience and thoughts with Mai for the purposes of the New Zealand report, which was issued in late 2019. Following the launch of the New Zealand report, we all planned to have Mai visit Australia, as Sarah mentioned, in the first half of 2020 to present on the report and to engage with stakeholders on a trans-Tasman and regional basis. Unfortunately, as we all know, the pandemic intervened and Mai was unable to visit. I'm hopeful that today's launch event, however, will pave the way for a visit by Mai to Australia in the near future. As many of you would be aware, the New Zealand report, Culturally and Linguistically Diverse Parties in the Courts, a Chinese case study, has generated a huge amount of interest among the judiciary and legal profession in New Zealand. In fact, I don't think that there is a single judge or lawyer in New Zealand today who would not be aware of the report or Mai's pioneering work in this increasingly relevant and important area. What's particularly noteworthy, I think, is that the New Zealand report highlights the challenges of super diversity, namely diversity that exists not just between ethnic minority and immigrant groups, but also within each of those groups and other groups. I had, of course, been aware of this reality, and indeed a key point that all of us have been emphasising from day one is the need to avoid treating people who share a particular ethnic or cultural background as a homogenous group. And this was in fact one of the key points included in the helpful guidance provided by the Supreme Court of New Zealand in the recent case of Deng and Deng, which cited the New Zealand report extensively. The New Zealand report, however, is groundbreaking in terms of capturing the challenges in this regard in a comprehensive and evidence-based manner. As noted by the issues paper that we're launching this evening, all of the recommendations in the New Zealand report reinforce the need to take a holistic approach to identifying and overcoming the challenges faced by culturally and linguistically diverse parties, both in the courts and in the legal system more generally. So the issues paper that we're launching this evening seeks to contribute to an understanding of these challenges by outlining the key findings and recommendations of the New Zealand report, by reflecting on the insights that those findings and recommendations offer to us in Australia, and by proposing an action plan for related initiatives. These include initiatives in relation to research, judges and courts, interpreters and translators, lawyers and professional education, engagement, policy formulation, and law reform. The issues paper is a modest attempt to move the debate forward and invites feedback on the issues by 31 October this year. Further discussion about the issues, I'm pleased to say, will occur at the National Summit of the Asian Australian Lawyers Association on the 1st of October this year, when May and I will have the privilege of joining a panel consisting of the Honourable Justice Emilios Kiru of the Court of Appeal, Supreme Court of Victoria, and the Honourable Justice Helen Wood of the Supreme Court of Tasmania. And let me thank His Honour, Justice Kiru, for attending this evening's launch in person. So let me now introduce our first guest speaker, who will help us to launch the issues paper. The Honourable Paul Coghlan, AO KC, is a former judge of the Supreme Court of Victoria, who sat in both the Trials Division and also on the Court of Appeal. One of Australia's most experienced judges in criminal matters, the judge is an alumnus of Melbourne University, and interestingly graduated in the same year as the founding director of the Asian Law Centre, Professor Malcolm Smith, with whom he had a close friendship. It's interesting to note that the judge has a profile at the Museum of Chinese Australian History in Melbourne by virtue of the fact that his grandfather, Qian Ah Fu, was a prominent Chinese merchant and community leader. And if my understanding is correct, Judge, your mother's generation knew William Arquette, the first Australian barrister of Chinese descent at the Independent Bar in Victoria. Judge, let me invite you up to say a few words. Thank you very much.
Thanks, Andrew. I also make an acknowledgement to country. And it's interesting, isn't it, in occasions like this, how we now make such concepts resonate in a way that we might never have done so in the past. I was born in 1944. The most significant thing about my Chinese background, about which I knew almost nothing, these things were not spoken about much, was that with my mother and my three brothers, in the days of rationing, it meant that we could get a bag of rice, a whole bag of rice, which was important not only for us, but for much of the community who lived around us, because we were able to share it. It meant I was exposed to going to the Chinese store in Little Bourke Street, and I can remember being there and not being much taller than the vegetable baskets that were there, and remember the coldness of the bluestone floor. I remember the old men at the back of the store playing what my mother always said was fantan, but if I spoke to the proprietor of the store, he said dominoes. And my mother looked fairly Chinese, that is Asian. That was not at the end of the Second World War in Australia. necessarily a good thing. The ability of Australians to choose between Japanese and Chinese, or if they could, to have really understood the difference, didn't happen much, and I think my mother suffered greatly. We were spared that in part by not talking about our Chinese background. But the fact of the matter was we had Chinese food for dinner every Tuesday night. Now, none of us ever asked, why do we do that, or inquired about it. But it was only probably by the time I was 14 or 15, I began to appreciate that we had a cultural history which was important. And it's in more recent times that I've in a way become the token Chinese judge on the Supreme Court, even though I'm only a quarter Chinese, and mostly because there isn't anyone else. So we've got to turn our minds to the question of, of getting diversity more into the legal system and particularly into judicial officers. And Anh Tran now has that opportunity as well to take things forward. Cultural diversity. What did we think about that as young practitioners? Did we know anything about it or think about it? We knew a little bit about language. We knew a little bit about sometimes there'd be interpreters used. Whether we appreciated the nuances of what was at play or not is not clear. My first real experience was one day I was cross-examining, this is many years ago, I was cross-examining a witness, and through an interpreter, and out of absolute frustration, the interpreter says, "It's no good." And I said, "What do you mean?" He said, "You're talking about the onions and he's talking about the garlic." So you did need to understand the nuances of what was involved in language, which are essentially cultural. That made me think about things a bit, and I've tried harder as my career has gone on to try and accommodate those things. It's important now, for instance, in the Supreme Court, that we don't say to jurors anymore, look at the witness and you'll be able to work out whether the witness is telling the truth or not. Well, that was our traditional view because we constructed our courts in such a way that the witness box was always immediately opposite the jury box. So the jury had this terrific view of the witnesses. But now we say to juries, don't do that. Try and take into account all the other features that are here. The difference in education, the difference in background, the difference in language. Because you'll often find people who are quite fluent in their second language, when you put them under a pressure of what happens in the courtroom, they won't necessarily cope quite as well. So they're all things we now need to take into account. I was reminded of the difficulties of cultural diversity when I was involved as the Associate Director of Public Prosecutions for the Commonwealth when we conducted the first war crimes prosecution of a man called Polyukovich in Adelaide. We brought all the witnesses out from essentially Ukraine, although they lived in a part of Ukraine in the southwestern corner, which had as much been in Poland over the years as it had been in Ukraine. The border had shifted on a number of occasions. And they spoke dialects, most of which were old-fashioned language. And one of the interpreters described it to me as saying, well, what he's saying is in yon forest. So not language of modern days in the way that we would appreciate it. But there were cultural difficulties or differences at play that I didn't pick up at the beginning. And one of those I should have picked up when they first arrived here and sent a message to me to thank me for taking them to the trade fair. And I hit the roof. Said, what have you done? I gave strict instructions about how these people would be brought here and they weren't to be taken anywhere and so on. Well, it turned out they'd got off the plane in Singapore and walked around the duty-free shop and thought that we'd taken them to a trade fair. So we're dealing with people with a level of sophistication a bit different from those that we'd understand. But it reached a crescendo at the stage that one of the men was giving evidence. Now, one of the great problems about interpreting evidence is it will never be the same interpreter. This man had given evidence back in Ukraine and it had been recorded, but it had been all translated, so the counsel in Australia cross-examining him are using that translation. A different interpreter is in court and translating his evidence. And as is the habit of barristers, somebody wanted to ask him questions about what he'd said last time. Now imagine the difficulty of that for a witness. Now, he's not even sure, because it's dependent on the interpreter, what it was he said last time, or he's not even necessarily sure of what he's saying this time, because again, it's dependent on the interpreter. So people then said, there's a solution to this. We'll play him the recording, the video of him giving evidence in Ukraine. So they played him the recording and asked him what you would think was the simplest question. Is that you? To which he replied, no. Not surprised, the counsel said, what do you mean, no? And he said, well, that's me in Ukraine, and I recognise that room in Ukraine, but I'm not there, I'm here, so it's not me. So they were cultural things at play that needed to have been dealt with in a quite different way. So we begin to learn. There are some things we've done here which are now helpful. For the evidence of children in sex cases, that's all recorded. In relation to child witnesses, we now have the provision for the use of intermediaries. And that's a useful step forward. That applies at the moment to children and people with mental impairments. But if you think about it, there's no reason why a whole process of intermediaries couldn't be used for people with both language and cultural differences to try and accommodate. And because what the intermediary process does is you work out how this person is going to be asked questions, and you have somebody, namely the intermediary, in court to help them if needs be. But the main emphasis on it is to say, ask short questions. Just ask simple questions that people can at least have a chance of responding to. And don't lead too heavily and so on. And I've had to go through the process. I had a case which involved a number of young boys who'd been charged with murder, and then a very large number of young witnesses. Well, we used intermediaries and we had hearings beforehand about how it was all going to work and so on. It worked okay. So I have some hope for that sort of thing. But what's important? Important is that we discuss and talk about these sorts of issues. The purpose of the paper. It is what we do is we start some discussion about the things that might be done. I think judges are alert to working out that people should be able to communicate what they need to communicate to the court and do it properly. The judges should be informed if there are cultural matters that will affect the issues in this case. We will not always be able to accommodate them, but that doesn't mean that we shouldn't be able to work them out. I mean, we're presently going through a phase in the operation of the criminal law in working out the question of consent for sexual offences. Now, that's very complicated, and there's a resistance at the moment, I suspect, to take into account any cultural issues, because we will have a community that will want to say, we don't recognise what your cultural background might be on the question of consent. So they're thoroughly difficult problems, and problems that we might, in terms of developing the matters that arise in this paper, discuss in more detail as we go along. I suspect that's getting to the end of my 10 minutes.
Almost.
I think about matters of some history. Arthur Call said in 1945 or thereabouts, the White Australia policy is a policy to restrict immigration to those who are related to us ethnically, who have much the same history as ourselves and share the same Christian ideals. So it wasn't about colour of skin. It was about an avoidance of cultural diversity. It was never quite true in terms of the way that it operated, because many people coming from Europe weren't going to quite fit the same categories, but that was the design. What, of course, it was very directly related to was the exclusion of Asian migration. Because you would have said, well, look, there's no history, no historical connection, there's no ethnic connection, there's no Christian connection. But we weren't ever quite prepared to express it in those terms. But it was to try and create a homogeneous population in a way that was never going to be completely satisfactory. And it's proved over the 80 years, well, not quite 80 years, 75 years since, it was not sustainable either. And that now, in Australia today, 30% of the population is born overseas. So if we extrapolate into that, those whose parents were born overseas, we'd get a very interesting statistic in terms of the things to which we should pay attention. Insofar as at least part of my task is to launch the issues paper, I launched the first third, is that right?
Yes, that's right.
I launched the first third. One last anecdote to finish with. Communication does not have to be spoken. In a case that I prosecuted, in relation to which the girlfriend of a girl had been abducted and violently raped by a number of men, was profoundly deaf. And she came to give evidence. She did not speak a word and could not speak a word. And she was having her evidence interpreted, her sign evidence interpreted for her by an interpreter who was herself marvellous, because she kept saying to these tough barristers, you can't ask that. And she got a lot of support from the judge who said, you got to listen to her. But it didn't matter whether any of it was translated, for we saw the expression on her face. We saw the absolute terror that she'd experienced when this event had taken place. So there are many ways that we may approach these things, and they won't always necessarily by language.
Thank you very much, Judge, for those thought-provoking comments, and also for helping to bring to life the myriad challenges that culturally and linguistically diverse parties face in the courts. So, and thanks also for launching the first third of the report. I'm not sure exactly which page that takes us to for Judge Tran, but I'm now delighted to introduce our second guest speaker to help us launch the issues paper, Her Honour Judge Meanne Tran. Judge Tran was appointed as a judge of the County Court of Victoria in October 2020, after 5 years working as a judicial registrar in the commercial division of the County Court. Her Honour now sits in the Common Law Division and is the judge in charge of the Family Property List. Judge Tran is also co-chair of the Diversity and Community Relations Committee at the County Court of Victoria. In Her Honour's remarks at the ceremony to welcome the appointment to the bench, Judge Tran identified diversity as one of the three things that she was most passionate about, alongside family and mentoring. A recording of that welcome ceremony is available on the County Court website, and I would encourage everyone to read it. It's a great thing to view, and if I may say so, truly inspiring. So, Judge Tran, may I invite you now, please, to launch the second third of the issues paper.
Thanks, Andrew. I too acknowledge the Wurundjeri people of the Kulin Nation as the first peoples and traditional owners and custodians of the land on which we speak today. I acknowledge the first people and traditional owners and custodians of the lands on which all the remote attendees are situated today. I acknowledge and pay respects to the ancestors of this country, my elders, knowledge holders and leaders past and present. And I do extend that respect to all Aboriginal and Torres Strait Islander people. Well, as a proud maths nerd, I'm launching the second third of May Chen's issues paper, and I'm also moving through the percentages. We've gone from 0, 25%, 50%, and obviously the guest of honour will have Melina at the end. I came to the bar actually 20 years ago this year, in 2002, Meanne Tran, barrister. And I thought today was a good opportunity to perhaps reflect a little bit on the process of change that I've observed over the last 20 years and that we still have to come. Following on with the mathematical theme, I've divided into 4 stages for the process of change. So back in 2002, when I came to the bar, there was certainly recognition of the concepts of equality and in a real sense, a practical sense, rather than a formal sense in academia. But in the legal profession, there was very little recognition of that concept beyond, formal equality, the reasonable man test. The bar to which I arrived was overwhelmingly comprised of white private school educated men. Any deeper analysis was really a topic for, reasonably radical academics and law students, not serious legal professionals. And there was not even a language, I think, to describe the sorts of things that now are kind of commonplace in discussion. I don't think I really came across the term person of colour until recent years. Terms like microaggressions, casual racism were not even available to me to describe the experiences I had back in 2002. So I thought, given, well, perhaps not here today, but online, I think we've got many Asian members of the legal profession. I'd engage in a little bit of group therapy and see if some of these things resonate for you. First of all, I arrived at the bar and I wasn't even aware of the existence of other Asian barristers. I know that there were, but they weren't present to me. Instead, there was a lot of well-meaning advice to change my name, a number of compliments on how well I spoke English, and this phrase, which I'm sure many of you will be very familiar with, "Where are you from?" I was certainly stereotyped as an Asian female and so best suited to work as a commercial junior, someone who could be relied upon to work extremely hard, but perhaps not so much someone to whom speaking roles should be given or who could be trusted to run cases. I faced, as I'm sure many of you have faced, that double whammy of having to work twice, 3 times, 4 times as hard to get anywhere, but then to have it assumed that I got where I got because of positive discrimination. I also faced that unconscious bias of it being assumed that you don't belong, that you need to show your pass, that you must be the junior solicitor or the secretary, not the barrister with the speaking role. And over it all, there is that pervasive sense of not belonging in the legal profession, because let's face it, I did not belong in the legal profession. So one of the things that I really liked about Mei Chen's report when I read it was the narrative approach that she adopts to her research, the stories she tells of the parties and also of the lawyers, the lengths to which she's gone to interview and hear the real stories of diverse practitioners, of interpreters and of the parties. We have certainly come a long way in 20 years. There is now a vocabulary, at least, to describe those microaggressions, to describe that casual racism, to describe all the things that continue to work to exclude the diversity in the legal profession, which we do so desperately need. But certainly there's a lot to be said for the fact that there's a long way to go. Which takes me to what I've called the second stage of reform, which is giving voice to the issue. And here really is the work that Mei Chen has done so extraordinarily well in her report. And it is so important to start that conversation and to hear the stories and to hear the diversity of stories. Of course, the starting point in any such conversation has to be a recognition that the existing system of legal rules and norms, which we call the Australian legal system, was imposed without consent upon the Aboriginal and Torres Strait Islander peoples and without regard for their laws, customs and culture, and continues to be so imposed today. And I think, as Justice Coghlan pointed out, it is really terrific and a really positive change that we're all acknowledging country as we go along. Then I do think it also has to be recognised that there's always been diversity in Australian society. It's not a new phenomenon. The man on the Clapham Omnibus has never been representative of the diversity of experiences in our community, including by reason of culture, race, religion, gender, sexuality, class and disability. And I am unfortunately very sorry to report that I still do hear in my courtroom reference to the reasonable man test on a regular basis. So what the report describes as super diversity makes the issue more visible, as does the existence of a language to describe the issue, which we've not had previously. But diversity and the need to find ways to address it has always been an issue within our legal system. And to me, if we are to address it, we do need to talk about it. And we do need to hear from voices such as Mei Chen's. We need to read and consider her very detailed and interesting report. And we need to strive to learn from it as a legal system. Sometimes people are afraid of diversity, that it will divide us. But to me, again, there's a unity that we need to find in recognising those differences and working towards respect, dignity and equal access for everyone. And we need to hear from other voices. I mean, this is really just the beginning. And I did want to do a little shout out to AALA, because one of the really terrific things about the AALA is the way in recent years they've gone out reaching to other diversity-based organisations, including them in their wonderful conferences, which are coming up in October. There you go, September 30th and 1st of October, diarise it. It's going to be a wonderful weekend. So there is a tremendous diversity that we do need to consider. And it is complex, it is difficult, but it's no longer good enough to shy away from those hard questions. It's no longer good enough to say, I will just deal with this form of diversity first, which is the easy case, and then we'll get on to the complexity. We were dealing To take an example with gender 20 years ago, Joan Rosenove was dealing with gender in 1923. If that's the easy issue, I don't know what the hard issues are going to be. We are supposed to be intelligent as lawyers. We're supposed to be able to deal with complexity, and the time has come to deal with that complexity, to deal with the intersections of diversity, to ask, for example, to take Mei Chen's report as a jumping off point, what does it mean to be a Chinese woman lawyer? What does it mean to be a Chinese person with a disability? But also, what does it mean to be a lower socioeconomic class person and a person of colour? What does it mean to be an Indigenous trans person? How are these impacts differently felt in criminal cases? And we've heard some wonderful examples from Justice Coghlan about that, in domestic violence cases, in civil disputes. How are these impacts felt in employment prospects in the law? These are complicated questions and complicated conversations, no doubt. But as lawyers, we should be able to deal with them, and the time to deal with them is certainly here. Okay, stage 3 is changing culture. In one sense, everything is culture, and there is culturally and linguistically diverse people, but there's also legal culture. There's the culture of the law. And I think as we have these conversations, we need to think about a change to the culture of the law, to one which embraces and encourages and accommodates diversity. One that doesn't start from an assumption that behaviours are founded in the white European culture, that is normal or objective or appropriate. So how can we have those conversations, and how can we change the legal culture to one which achieves what we're all fundamentally about at the end of the day, which is equal access to justice, respect and equality of opportunity? And how do we fit all of these concepts into our very ingrained legal principle of the reasonable person? Andrew, you also stole my thunder a little bit. What I was going to say next is one of the very difficult things that we do need to navigate is that tightrope between cultural awareness and cultural stereotypes. And that is a very difficult tightrope. And I did see in Deng and Zheng that New Zealand Supreme Court really raised that issue and discussed that issue as one that we have to navigate. It's one that I see in my courtroom all the time. It's one I see in mediations all the time, is where stereotypes operate rather than cultural awareness. So that's something that we do need to be very conscious of. And then stage 4 is practical change. It's all very well to talk about these theories and these lofty concepts, but at the end of the day, what really matters to people is equality of opportunity in employment, equality of opportunity into positions of power, and equality of access to justice. And again, Mei Chen's report is really good in the way it comes back to those practical recommendations, some specific practical recommendations for how the legal processes and procedures can be changed in order to better accommodate specifically Chinese litigants. Now, I have to say, as a hardened civil litigator, I don't necessarily agree with all of those practical reforms that she suggests, and I'm sure that's an interesting conversation that we can have. May, but certainly those topics that she talks about, interpreters, and we've heard already from Justice Coghlan about interpreters, and the number of times I've heard in the courtroom a barrister sort of with frustration say, just interpret the words, Madam Interpreter. There is no such thing as just interpret the words, and to some extent I think a really good interpreter does perform that role of cultural consultant. And it's such a fraught role because you're interpreting legalese into English, into another language, and then back to English. And, you know, I certainly in my courtroom don't have any problem with what sometimes occurs, which is a barrister asks a question, interpreter interprets something to the witness, witness says something back, interpreter says something back, then witness says something back, then interpreter says, yes. Case management, ADR. I thought the ADR, and I talked about this with Andrew before, there's an interesting observation in Mei Chen's report that she didn't think that Chinese were receptive to the concept of ADR. Now, I have conducted a lot of mediations with Chinese parties in my former role, and I found it really an extraordinarily productive way to resolve a dispute, particularly in the context of those cultural issues about hierarchy and face and the importance of negotiation and status in any resolution of a dispute. I think there's tremendous potential for ADR to provide the flexibility to accommodate for cultural differences and to respect cultural differences in a way that perhaps may be more difficult for us in the formal courtroom concept. And of course, Mei Chen did win my heart by making specific reference to my other passion, which is mentoring, which to me, I think is going to be absolutely crucial in enhancing the diversity of the profession going forward. So all of that's a bit of a rant about diversity. Andrew did warn you it was one of my favourite topics and they let me loose. But I just wanted to conclude by saying that diversity is a fundamental part of our society. It has always been a fundamental part of our society. It's not a problem to be solved. The problem is the legal system and how we deal with it. This report, I think, is a really interesting and important step along the way to the cultural and practical reform which must occur if we genuinely believe in access to justice and equality of opportunity. And I just wanted to quote from Audre Lorde to finish up. Certainly, there are very real differences between us of race, age and sex, but it's not these differences between us that are separating us. It is rather our refusal to recognise those differences and to examine the distortions which result from our misnaming them and their effects upon human behaviours and expectation. So it's my pleasure to launch the second third of Mei Chen's report.
Thanks very much, Judge Tran, for sharing with us your own personal story, but also for helping us to understand better the language of diversity in all its forms. And I think it's really important to acknowledge the extent to which diversity does come in different forms. And we shouldn't look at it in a monolithic or limited way. So we've now launched 2/3 of the issues paper. But before I invite Melina to launch the last third, the third third, as it were, it's my great pleasure now to invite the co-author of the issues paper, Mei Chen, to say a few words, and also on my part to thank her very much for her leadership today in writing the report and also being involved in the issues paper. There's a lot that I could say by way of introduction about Mei. Like Judge Tran, Mei is very passionate about diversity. Her background details reveal an impressive list of achievements, including the establishment almost 30 years ago of Chen Palmer, New Zealand's first specialist public law firm with Sir Geoffrey Palmer. Other achievements include Mei's service as the inaugural chair of both New Zealand Global Women and Super Diverse Women, her service on the boards of companies and public institutions, and more recently, I think it's only a couple of weeks old, this news, Mei's moved to the bar and the launch of the Specialist Chambers Public Law Toolbox Chambers. So congratulations in particular, Mei, on the recent achievement and best wishes for your work at the bar. But before you go back to working on that brief that you've received already, it'd be great to hear from you. And once again, to thank you for all the effort that you put into this pioneering work. Thank you.
Great, thank you so much. Kia ora tātou. It's wonderful to be with you all tonight. And can I acknowledge the Honourable Paul Coghlan? I note that your grandfather was called Chen Ah Fong, so we share a surname. And to Your Honour Judge Tran, thank you for raising belonging, because it's important that I talk about belonging with respect to Professor Dr. Andrew Godwin, Professor Biddulph, Melina Asthana, Sining Wang, Matt Floro, so many people actually who are Australian lawyers. And even though the work was done in New Zealand, my family, the people who nurtured me and encouraged me, were in Australia. So it's right and fitting that I produced this co-authored report for Australia with Andrew. And I'm grateful that you think this is important, because I'll tell you what a similar paper like this did in New Zealand. You see, there was a problem which resulted in a need for this paper. New Zealand is super diverse, defined as 25% or more of the population not born in the country. We are 30% really. And actually, when I look at Melbourne, into which I'm beaming tonight, and then Sydney, I note that you are also super diverse societies. And what had happened was that in our High Court, we had an increasing number of super diverse parties, many of whom didn't speak English, represented themselves, and were busy suing each other. And so the judges in the High Court were really desperate to get some assistance with the issues that they were facing, because the counsel that were appearing for the parties didn't necessarily know how to assist the judges to ensure that they could put a social and cultural lens on what was being said, what was being done, and what the motivation and intention was of the actions that were taking place. So it fell to me to have to write the report to provide some assistance. And I saw a gap. So I approached the Chief Justice, who kindly got her office to see if judges would like to volunteer to be interviewed. So a dozen of them volunteered, and that's how it all started. A dozen volunteer judges at all levels. The High Court ones were beside themselves because they were dealing with these issues on a day-to-day basis. And Judge Tran, I just want you to know that when I presented to the Auckland High Court judges, and of course Auckland is the fourth most super diverse city amongst the OECD countries, they said that one of the very great problems they had was getting the parties to settle. Cases that made no sense. They were fighting over 15,000. They both had very expensive counsel and they wouldn't settle because of big face issues. So it's great to know that if you get a barrister who knows what they're doing, you can settle these cases. But along with that, the report was drafted and ultimately it was launched in November of 2019. Now, let me tell you what happened after that. We then had a case which was then called Singh and Thing, and it went through the High Court and it turned up in the Court of Appeal. So this was 1 year later that it turned up in the Court of Appeal. And Justice Goddard, writing for a bench of 3, said that he felt very, very uncomfortable with the decision that had been come to in the High Court. And so he raised a note of caution. He cited the Called in Courts report that I'd written in New Zealand. And then, of course, he talked about the absence of any evidence that would assist in interpreting the cultural and linguistic dimension of the parties' dealings. It identified that almost all primary records and parties' correspondence were in Mandarin, and the English translations relied upon were prepared by different translators. So, just the Honourable Paul Coghlan, here we go. Different translators and at different times putting forward different translations of the same terms. In particular, different translators use different terms in their English translations of the term gongshi, which could be translated as either firm, company, or enterprise. Furthermore, none of the translators gave evidence about why they used certain terms rather than other terms in particular documents. And so therefore there was a real risk of nuances in expression and context being lost in translation. This case was about whether or not the dealings between the parties were tantamount to a company. Were they in a partnership? And so it went from there because the Court of Appeal then decided to reverse the decision. So it went on appeal to the Supreme Court. The Supreme Court granted leave, and this is what the Supreme Court said. They referred to the part where the judge talked about caution. They referred to the part where the judge had referred to Called in Courts report in New Zealand. And the Supreme Court granted leave and held that it may be necessary to explore these cultural and linguistic matters to resolve the appeal. They then invited the New Zealand Law Society to consider intervening in the appeal after consultation with New Zealand Asian lawyers. Well, I'm the president of New Zealand Asian Lawyers, and I appeared in the Supreme Court along with 2 other lawyers on behalf of the New Zealand Law Society. And of course, the rest is history, because in 2022, the Supreme Court did what we asked them to do. We said that it was critical that our top court provided guidance to the courts beneath them as to what needed to be done, because the reality is that we were continuing to have cases like this. And I'm quoting now from a case in 2019. And this is a wonderful judge called Justice Toogood, but this is what he said. The plaintiff provided no independent evidence that there was any customary practice in Chinese culture for the payment of a dowry by an internet husband to his intended wife or family. The dispute about the existence of such a custom, as is alleged, might have been easily resolved by evidence from an independent expert, but there was none. Ms. Tien suggested in evidence that evidence of the custom would be found on the internet. But the court is not disposed to Google its way past the inadequacies of the plaintiff's proof to find the answer. So in 2022, a month ago, when the Supreme Court decision came out, I gave a seminar. And at the seminar, let me tell you, this subject that really hadn't been talked much about in New Zealand was attended by 350 lawyers, barristers, lawyers, those appearing for super diverse parties in the courts. And I asked Justice Goddard, who'd written the Court of Appeal judgment in Dinginson, I asked him whether he'd seen social and cultural and linguistically diverse parties represented well in court, and his answer was no. But he did say that he'd seen some well-done cases when Maori Council had appeared, that's our Indigenous peoples, who understood the cultural context and were able to explain it to the judges, for which he was very grateful. Now, I note that Justice Amelia Kiru is currently in the audience. And can I say that even this weekend, Your Honour, because of course, Dr. Andrew Godwin introduced me to Justice Kiru's work, I cited it profusely in the New Zealand Law Society submissions to the Supreme Court. The Supreme Court quoted Justice Kiru twice, and this is what happens now in our major newspaper on a regular basis. There is a case at the moment in New Zealand. It's a serious fraud office case. It's about Chinese people making donations to political parties. And the question is whether they were trying to circumvent the law by splitting up the donations so they didn't have to be declared. So here is a QC, and he is saying that what has happened here is that the Serious Fraud Office has failed to put a proper social and cultural and linguistically diverse lens when they determined what was done and why it was done. And then Paul Dacre QC, well, he would be KC now, quotes Australian Justice Emilios Kiru advising judges to develop, quote, a mental red flag cultural alert system, which gives them a sense of when a cultural dimension may be present, so they may actively consider what, if anything, should be done about it. So the reality is that the learnings from Australia, not only did you give me a sense of belonging there, all of my colleagues there, starting with Professor Bidoff, through to Andrew, and through to Sining Wang, practitioners there, who talked to me before I appeared before the Supreme Court, to the situation now, actually, where we are quoting Australian judges in New Zealand when our Supreme Court gives guidance about how you put a social and cultural framework on the Evidence Act. When do you need an expert? And this is an important issue because ultimately we are talking about equal access to justice. If you require it too often, then it makes it very expensive for somebody who doesn't speak English and who comes from a different culture. If you require it too little, then you leave the judges to DIY and to try and feel their own way. And you may also force them to force interpreters and translators to become the cultural consultants that Judge Tran talked about. But of course, this white paper that we're launching tonight is only the beginning. And can I say that there will be a global symposium on cultural experts in courts in the Sorbonne from the 7th to the 9th of April 2023. The Super Diversity Institute that I established will be running that together with Cultural Expert and the Institute for Advanced Legal Studies of London University. And it will be very interesting there, Judge Tran, for us to explore that whole concept of cultural expert, because one of the things our Supreme Court did say in its guidance was that judges, of course, could avail themselves of such cultural experts. And the hint was that they should, where they felt out of their depth. So in closing, can I say these issues aren't new. They're absolutely not new. When we are dealing with foreign contracts, we have to deal with interpreters. We have to deal with cross-cultural determinations by judges applying their common sense as to whether or not what we assume or our predeterminations about how, you know, partnerships might work or contracts might work apply in this particular situation, whether that be Italian or French. It just happens to be that New Zealand is super diverse. We have a very high number of Asians in this country, and also we have the biggest Pacificicity in the world, together with a very significant number of Indigenous peoples in our country who, of course, also have a different language and have a very different culture. But I want to say that a start is being made today, and I confidently predict that the work that Andrew has put into this, and can I really say to Dr. Andrew Godwin, I'm so enormously grateful to you. You have encouraged me to continue to work in this very important vineyard. I think it's a vineyard, I'm not sure what it is, but it's certainly been a lot of work. Look, it's an important issue, and it's a particularly important issue if we are going to ensure equal access to justice, because judicial common sense left to itself could also mean that we bring in subconscious bias and that we bring in the stereotyping, which is unacceptable if we're really going to get to the bottom of what was said, what was done, and what was truly intended. So I simply want to close so that Melina, can I thank you for the support of the AALA. The New Zealand Asian Lawyers is only fledgling compared to the Australian Asian Lawyers Association. I would very much like to establish it so that it is as good as your organisation, and then I look forward to handing it over. But I just want to say that I would like now to stand back and look at what impact it has as you consider, submit on, and we develop and evolve this white paper into all it should be, because I think the same issues that we've experienced here will be experienced in Australia, in your Australian context. And just as you've had so much to teach us, I think that as iron sharpens iron across the Tasman, we're going to find that there are lots and lots of learnings, which ultimately should ensure that regardless of which culture you come from and which language you speak, it shouldn't make a difference. At the end of the day, I look forward to the day when culture, gender, ethnicity, language, none of these things matter, because we all come from different identities, but that judges and courts are equally adapted and have the expertise and the capability to properly interpret and deal with these issues, properly context these issues, so that it makes no difference to a person's ability to get equal access to justice in the courts. Thank you.
Thank you very much, May, for joining us virtually in the vineyard, I think, of cultural diversity. It's just unfortunate that you can't be with us here in person to drink the wine that we'll be having after the issues paper has been launched. but I expect that it won't be too long before we can entice May to come across the Tasman to continue the discussion and to spend much more time talking about all of the relevant issues. So thanks very much for that. Last, but certainly not least, I'm delighted to invite Melina Asthana to close this evening's launch event. Like the other speakers this evening, Melina has a long list of impressive achievements. Prior to coming to Australia, Melina practiced law in India for 7 years, where she came from a family of eminent jurists. Melina was a principal solicitor with the Victorian Government Solicitor's Office for over 10 years before setting up her own practice at Swarup Asthana. Melina sits on the board of the Law Institute of Victoria and is the first South Asian woman to be elected president-elect of the Law Institute of Victoria. She's very well known for her work in law and sport and is the founder of Multicultural Women in Sport. Melina is also a member of the Football Federation of Victoria Tribunal. This evening, Melina is appearing in her capacity as president of the Asian Australian Lawyers Association. Melina speaks regularly on the subject of diversity and inclusion and has received many awards for her work in this area. Melina, could I ask you now please to say a few words and close the event for us, and of course launch the third of the issues paper.
Thanks, Andrew, for your kind words in the introduction. I know I'm standing between you and the fabulous wine that has been put up and the beverages, so I will try and keep it brief. I also want to begin by acknowledging the traditional owners of the lands on which we all meet in different parts of the world today, and pay my respects to their elders, past, present, and emerging, and to any other elders who may be joining us today. For those who are not familiar with the Asian Australian Lawyers Association, it is the national peak body for Asian Australian lawyers and lawyers with an interest in Asia, regardless of their background. AILA is fundamentally committed to advancing cultural diversity in the law and connecting Australian lawyers with Asia. With branches in every state and territory across Australia, AILA is a national not-for-profit volunteer-run organization with over 1,200 members. Though I am a commercial lawyer, I want to narrate some instances that highlight the importance of this issues paper. I was appearing as an expert witness in a family law matter and was asked to provide evidence on the practice of dowry. The judge found it very difficult to understand the concept and could not fathom why the bridegroom's sister living in Australia was given any money by the bride's parents, particularly a very large sum. This is common practice in South Asian community, and May has already highlighted that when she spoke, where large sums of money and other forms of wealth are given by the bride's parents to the bridegroom's relative and is traditionally meant to be the women's wealth. The judge eventually decided not to take account of any form of dowry given when distributing the assets, which left the woman financially worse off. The law has now changed in Victoria through the work of some of us, and now dowry is included as a form of economic abuse in the family violence legislation in Victoria. In another context, a victim of family violence who I was advising when volunteering at a community legal center and who was not fluent in English was asked to speak to an interpreter over the phone. And she refused to do so because she was worried that the interpreter would be from the same community and that it would not be safe for her to speak to that person, and it may bring disrepute to her and her family. Most recently, as president of the Asian Australian Lawyers Association, I was requested to appoint an expert to advise the family court as to the effect and enforceability of the parties' court proceedings in China. The expert was required to have relevant expertise in family law in both the Australian and Chinese jurisdictions. This is an unusual request for us, as it would usually go to the president of the Law Society, but something that will probably become more common. The issues of access to justice and the court system are unique to countries that have a diverse population, particularly Australia, where over 51% of the population was either born overseas or their parents were born overseas. Unique issues require unique solutions, because justice should not only be done, but seen to have been done. That is why the research that has been carried out by the Super Diversity Institute, led by Mei Chan, is revolutionary and has the potential to remove many barriers to access to justice for CAD litigants in the court system in Australia. I am really grateful to May for agreeing to our request for contextualizing her New Zealand research for Australia, and for Professor Andrew Godwin for partnering with her to author the issues paper. I want to thank them both for their generosity of time and efforts and their willingness to take into account the feedback that we provided. I want to thank former Justice Paul Coughlin, AO, QC, or is it KC now? I'm not sure. And Her Honor, Judge Mia and Tran, both who have been long-term friends of the Asian Australian Lawyers Association, for taking time out of their busy schedules to address us and to share their insights, and for also launching the issues paper in parts. It is insights like these from our diverse and eminent members of the judiciary that enrich the work that we have undertaken. I would also like to acknowledge the presence of Justice Emilos Kiros, who will be speaking at our national summit very soon. We are very thankful to him for doing so and also for attending today. I also want to thank Melbourne Law School and in particular the Asia Law Centre, Professor Sarah Bidalf and Professor Andrew Godwin for hosting us today, for providing us with this state-of-art venue and the catering that we will shortly enjoy. The technology here has permitted our members and others to join in by remote from all parts of the country and overseas. And I want to thank the team at the Melbourne Law School for enabling us to do so. I also want to thank the rest of our Asian Australian Lawyers Association team who contributed to the issues paper. The names are listed out in the issues paper, and to those who assisted with the launch, in particular Ahalya Kaminini, our National Media and Policy Subcommittee Secretary. I also want to acknowledge the presence of our my predecessor, Kingsley Liu, who is here today as well from Sydney, and of course, former Justice Diana Bryant, AO, KC, I believe, our national patron. Thanks to all those who have joined us in person and by remote. It gives me immense pleasure to launch the last part of the issues paper. And I invite you to provide your submissions to the issues paper so that we can produce a comprehensive report that takes into account the Australian legal landscape. We can send you a copy of the issues paper if you would like to have a read. Well, let's continue our conversations over some refreshments. Thank you.